publicly available data generated on the fly, which is out there and is publicly available. The same choices may not apply to all types of content, but you will know where your commercially valuable content is, and you will know how you feel if some of that ends up in somebody else's RSS feed or otherwise. Thirdly, in deciding, and maybe this is more one for the lawyers, but in deciding legal issues like data ownership and liability for illegal content, the law should take an effects-based approach and not a technology-based approach. In other words, let's look at what the net effect is of using that technology, not the actual machinations, the actual technical means by which it works. So in order to decide questions about ownership and liability, we should focus on the commercial effects and not the technological process itself. We, and I mean the industry and everyone involved in the industry, and indeed the content industries generally, we need a clear understanding and a consensus about what an intermediary is on the online world. There is, or should be, a clear distinction in the legal responsibilities of a provider of search and other location tools to users on the one hand, and on being a data aggregator or publisher on the other. And I know this is complex because, as we've seen, we can be playing both roles. But even if we do play both roles, then okay, different legal consequences should apply. Fifth, and I think actually the most important, is to recognise that the solutions to all these challenges will not be found in courts of law. Yes, of course, legal action will also have its place. Piracy and other illegal acts need a legal response. But above all, what we need are creative business solutions between all players in the value chain who benefit commercially from the use of other parties' contents. We need collaborative partnerships of the kind we've been talking about this morning, and revenue-sharing deals, and a whole variety of commercial solutions, including paid-for content. And I think the best example is Google, who built a massive business despite the legal uncertainties surrounding their activities. And yes, of course, perhaps a seventh one, again, more for lawyers, all of this stuff, all of these issues have to result in policies. You know, what is our policy about monitoring content if there's user-generated content? In some instances, it may be entirely appropriate for the business, in others not. So all of these issues need to come down to policies, because policies are about risk management. The law is going to take time sometimes it's ahead, sometimes it's behind, but in the meantime, one has to take sensible, risk-based solutions and policies to these sort of challenges that we have ended up in. And I'm sure that these same questions will continue over the next couple of years. Thank you very much indeed.
Thank you, Laurence Kaye. If there are questions for Laurence, please raise your hand. Just stay another moment. There was on Twitter, one of the remarks that was made is that it was not about the mashups and the risks of extracting content, etc., but the real problem is that this remark says that Yellow Pages are worried about protecting content instead of worrying about distributing it. Control the syndication, this tweet says.
Well, I think all the publishers that I speak to, in whether it's this industry or any other industry, are saying we're not in the business of locking up content. In fact, many publishers, especially, let's say, e-book publishers, are moving away from using technical protection measures to restrict content. That said, there's no business without getting the content out there. That said, and I think this is the missing link, if stuff is out there and people have no idea on what terms you can and can't use it because the technology isn't in place to express those permissions in a way that search engines can read it, we'll never resolve that conundrum. That's the bit that's missing.
Mm-hmm. Okay, and then I have a question. Am I free to go?
You are, Toon. Hopefully, if you ended up in court on Tuesday, I'm very confident that we're going to win that case, so don't worry. Have a nice weekend.
Okay, thank you very much.
Just one, sorry.
Oh, sorry.
Sorry, just have...
I'm sorry, I hadn't seen.
Thank you, Laurence. I thought it was very interesting, your presentation. I have one concrete question. We we have a website in Switzerland which is recently launched called okiku.com. And one of the features of this website is a ratings and review of businesses, professionals, and professionals. But that includes doctors, lawyers, and dentists, and so on. Let's imagine somebody makes nasty remarks about a lawyer. And
God forbid.
God forbid. Not defamatory remarks, but he's not happy. So the ratings are not particularly positive. And the lawyer, we envisage this, the lawyer's going to write us a letter saying, these remarks are untrue, they're not justified, could you please remove them from the site? Our intention is not to remove them, but what is the legal position? We've said in the terms and conditions, we own the content, the remarks, the ratings and review that people make. But first of all, is that true? And secondly, in a case of a doctor or dentist or lawyer, is there some legal obligation when the remarks are really negative for the professional's business activities? Is there any legal obligation for us to act?
Right.
Assuming it's not insulting language or political or sexist.
Right, so I've only got 100 witnesses to the advice line. Now, it's a Swiss company.
It's a Swiss company.
Okay, so that would be an issue of Swiss law, which obviously is not subject to the same... Let's imagine let's move it into Germany, so it was under German law. There's three separate questions. First of all, the person... If I post something about somebody else which is defamatory, I mean, I as the poster could potentially be, could end up getting sued. That's the first thing. If you are the host, you are hosting the rating reviews or other content in forums that are being provided, and I'm assuming that you'll have rules in your forum. If you haven't monitored, you're not reading those reviews, and it is a defamatory. Let's say it is a defamatory statement. You have a choice. You would have a choice. You would either say, we'll take it down and we'll investigate it. And that would, if you were in Germany, that would give you immunity under the hosting exemption. Because as long as you take it down as soon as you know, you act expeditiously, you're okay. But let's say you take a decision not to do that because you think, as a matter of editorial integrity, it's going to destroy the site if you constantly do that. Then what you've done is made a business decision to trade your legal immunity for the sort of, if you like, editorial policy of your site. And you'll need, hopefully a good insurance policy to protect you against those sort of claims. And obviously you might engage, there might be opportunities to engage some further feedback. But in Europe, you do run a risk.
If I can, so impolite to interrupt, this could go on for a little while. I mean, your answer and the problem. I have another problem. It's a timing problem, and perhaps that if.
Okay, thank you very much. Thank you.